Hi. Today we'll be seeing the obligations of a banker. What is the obligation that he needs to execute for the customer to the regulators? So, if court order comes, a Garnishee order is issued, how it is acting on various types of accounts. So, will be seen in today's video. So, what are the obligations of a banker? The primary relationship between a banker and a customer is that of a debtor and a creditor, or vice versa, depending upon that we have seen in the previous video, depending upon the types of account which he is maintaining. So what is the main obligation? The obligation to honor the instrument, that is the main thing, under various circumstances, how it is executed by the bank and how he acts against non-execution, under which circumstances. So these are the things will be covered under the obligation to pay the check. So what is the second obligation for a banker? To maintain the secrecy of the account, whom he can disclose and whom he cannot disclose the balances and the transactions that is happening in the account will be seen in the second topic, where the secrecy of the account is getting maintained. So what are the disclosure that is permitted by the regulator as well as by law will also be seen. So these are the main topics that gets covered in today's obligations of a banker. Obligation to honor the instrument. Deposits accepted by a banker or his liabilities repayable on demand or otherwise. Otherwise is given because of ATM withdrawals without demand that is happening. Under a statutory obligation to honor his customers' checks, Section 31 of the Negotiable Instrument Act 1881 lays down the drawee of a check. That means a person who is having an account, having sufficient funds of the drawer in his hands. Drawer is a bank. Properly applicable to the payment of check, must pay check when duly required to do so, and default of such payment must compensate the drawer for any loss or damage caused by such default. So this is the law. The drawer of a check. So drawer of a check is person who signs. Drawee is a bank. Payee is the beneficiary to whom the amount is being paid. Drawer and payee, beneficiary, and then drawee is the bank. So these are the three parties involved in a check payment. There must be sufficient funds in the account. So funds meaning unrealized amounts cannot be considered. If unrealized amounts are given there, it will be returned as effects not cleared. So the credit balance in other accounts of the customer will not be considered for honoring a check which is given in one account. So there was a court case in that, Muhammad Hussain versus Chartered Bank in 1965. So it was held that though the bank had the right to combine several accounts of its customers, the customer had no right to require the bank to combine the different accounts in determining whether a check on account may be dishonored. So the customer was complaining, I had balance in other accounts, why the bank did not consider before returning the instrument in one particular account. So customer cannot claim as a right that the banker has to combine all the balances in other accounts to honor an instrument which has come in one single account. The funds must be properly applicable to the payment of a check. A customer might be having several bank accounts in his various capacities, but it is essential that the account on which the check is drawn must have sufficient funds. Similarly, a depositor having debit balance in his current account cannot draw a check on the basis of fixed deposit with the banker. So the banker's obligation to honor the check, expressly or impliedly, the customer should be giving in writing with proper balance in the account. In the case, banker's obligation to honor customers' checks is extended up to the amount of overdraft sanctioned by him. So there are two types of overdrafts which is coming. Overdrafts based on some securities, even it can be fixed deposit, or overdraft given within the discretionary power of the authorities, which is called temporary overdraft. That needs to be cleared within 14 days of time. If the banker reduces the limit of overdraft or withdraws it altogether, He must honor the checks issued by the customer before the notice of such reduction or withdrawal is served upon him. So even if it is temporary overdraft, which is implied agreement, there is no written agreement. Even if it is being withdrawn by the bank without the discretion of the customer, if the check returns, the banker is liable to pay the damage for the customer. Meaning, say for example, a bank is allowing 5,000 rupees above the balances available in the account consistently for 2-3 years. Suddenly the bank cannot withdraw that facility. They have to give in writing, even though there is no implicit agreement, they have to give in writing that I am withdrawing this 5,000 rupees facility which I have extended into the account, in case they want to stop that kind of offer to the customer. There was a court case also in that. The bank permitted a customer to enjoy overdraft facility to the extent of 5,000 for a period of 4 years without requiring him to execute any document for this facility. Subsequently, the bank dishonored a check of 3,900 because of insufficiency of funds. Bank contended that the transactions clearly showed that it was only a facility and not a contract. It amounted to a personal arrangement with the agent of the bank and did not constitute a contract. The High Court held that overdraft dealings between the bank on the one hand and the customer on the other hand during the period for 4 years clearly lead to an inference that there was a contract between the customer and the bank in respect of overdraft facility. The uninterrupted enjoyment of this facility could not have been terminated by the bank unilaterally. So this was the decision given by the banker. The banker must be duly required to pay. This is the third condition under that. This means that the check, complete and in order, must be presented before the banker at a proper time. So stale instruments cannot be paid. Stale instrument, the bankers can dishonor the check. So what is post-dated check? Check which is dated for the future date will be dishonored. The validity of the check is 3 months. Any check which is prior to 3 months, means 3 months before, will be dishonored by the bank. Okay. What is a Garnishee order? How should bank act if it is served on the banker? It is an obligation of a banker to honor the customer's checks is extinguished on receipt of an order of the court known as Garnishee order. If a debtor fails to pay the debt owed by him to his creditor, the creditor may apply to the court for issuance of Garnishee order to the banker on his debtor. Such order attaches the debts not secured by a negotiable instrument by prohibiting the creditor from recovering the debt and the debtor from making the payment thereof. In other words, I'll put it a little simply. Supposing you have as a banker, you have a customer who has to pay some X amount to other party. The other party can go to the court and get an order injecting fees into the account of your customer. In that case, once Garnishee is served, any other check coming into the account will be dishonored even if there is a balance in the account. There are two parts in it. Banker to stop payment out of judgment debtor. See, there are two things in it. That's called order nisi. Banker is prohibited from paying the amount due to his customer on the date of receipt of this. So, other one is order absolute, whereby the entire balance in the account is blocked. So, in order nisi, only the specific amount is blocked. There is second type of Garnishee order where it is called order absolute. The entire balance in the account is blocked, freeze. Then the Garnishee order were various types of account. In case of joint account, 2 or more persons will be there. One of them is judgment debtor. The joint account cannot be attached. So if there are 2 people, it cannot be attached. Say for example, A owes debt of ₹1,000 to B in his personal capacity. Then B cannot pray for the attachment of joint accounts of A and C. But A and C are jointly responsible for the debt. Their joint account may be attached. If they are jointly responsible, then joint account is attached. Otherwise, no. In case of partnership account, a debt taken by a partnership firm, the personal accounts of the partners can be attached in addition to the account in the name of the firm. Trust accounts, trustee holds the funds or property of someone else for the benefit of the beneficiary. Hence, trust account cannot be blocked. Attachment order by the income tax authority. If it comes, then what should you do as a banker? The credit balance in the account of a customer of a banker may be attached by the income tax authorities. If the customer defaults in making payment of the tax due from him. Section 226(3) of the Indian Income Tax Act 1961 gives authority to the income tax officer to do it. The income tax officer may 1. Attach any debts due and payable. Number 2. Debts due but not payable on the date of receipt of the notice. Number 3. Any amount received subsequently. All these 3 situations, the income tax authority has the right to do it. After making payment as required under this section, banker shall be fully discharged from his liability to the assessee to the extent of the amount paid to the income tax. No attachment of unutilized overdraft account. Supposing overdraft account is there, unutilized fund is there. 10,000 rupees is the overdraft account sanctioned. He has used only 2,000, remaining 8,000 is there. That cannot be attached by any law. So overdraft account does not render the banker the debtor in any case, in any sense, and therefore attachment order cannot be issued against unutilized portion of cash credit or overdraft account. Liability of a banker in case of wrongful dishonor. A banker has a statutory obligation to honor his customers' checks unless they are for valid reasons. In case bank dishonors a check intentionally or by mistake, he is liable to compensate the customer for the loss suffered by him according to section 31 of the Negotiable Instrument Act 1881. This is the one we have seen in the beginning of this video. There is one another system which is being introduced by the bank recently, positive pay system. In that, in case you are issuing a check for beyond 50,000 rupees to any amount, you have to give instruction to the banker that with the check details and the payee detail to avoid the frauds in the form of payment of checks. Certain banks have made this as voluntary up to 5 lakhs, and 5 lakhs and above it has been made mandatory. Certain banks say anything above 50,000 has to be informed to their bank once the check is issued. This is called positive pay system. So this is one of the obligations which as a customer you should keep in mind. In case of traders, there is a natural presumption in law that a trader suffers loss of reputation in case his check wrongfully dishonored by his bank. So special damage could be awarded by the court for the bank. So obligation to maintain secrecy of account for the banker. The account of the customer in the books of the banker records all of his financial dealings with the letter and depicts the true state of his financial position. So banker therefore under an obligation to take utmost care in keeping secrecy about the accounts of his customer. And then which are the when can the bank deviate this particular secrecy of account? As required by the law. A banker is under statutory obligation to disclose the information relating to his customer's account when the law specifically requires him to do so. Hence, they are not bound to disclose any information about the customer's account under this Act if it is coming under Right to Information Act. Banks doesn't fall under RIT, and hence banks do not have any obligation under that. Under the Companies Act, produce all books and papers or relating to the company which are in their custody or power. Otherwise, to give the inspector all assistance in connection with the investigation which they are reasonably able to give. This is for the companies. Under Book of Evidence Act 1891, the banker is bound to do so when the court orders the banker to disclose information. Under the Reserve Bank of India Act 1934, RBI collects credit information from banking companies and also furnishes consolidated credit information from the banking company. Every banking company is under a statutory obligation under Section 45B of Reserve Bank of India Act 1934 to furnish such credit information to the Reserve Bank. And then disclosure to police in case the police officers conducting an investigation may also inspect the banker's books for the purpose of such investigations. And then under FEMA 1999, Section 11(2) of the Act, to direct authorized dealers, which is bank, in foreign exchange to furnish information as may be specified about the customer. And the last one is Credit Information Companies Act 2005, 17(2) states the credit institution, a member of credit information company, to provide credit information to the credit information company. So under these obligations, the banker is liable to disclose the secrecy, break the secrecy and disclose the information about the customer. And as I told, bank doesn't fall under Right to Information Act, so no public can directly ask for the details of any of the customers to the bank. So with express or implicit consent of the customer, banker will be justified in disclosing any information relating to his customer's account with the customer's consent. For example, if oral enquiry is made at the counter, the bank employee should not speak in louder voice so as to be heard by other customers. Similarly, the passbook must be sent to the customer through the messenger in a closed cover. Banker generally does not disclose such information to the customer over the telephone unless he can recognize the voice of the customer. Otherwise, he bears the risk inherent in such disclosures. In certain circumstances, the implied consent of the customer permits the banker to disclose the necessary information. Say, for example, if a banker sanctions a loan to a customer or the guarantee of a third person, and the third person asks the banker certain questions relating to the customer's account, banker is authorized to do so because by furnishing the name of the guarantor, the customer is presumed to have given his implied consent for such disclosure. Banker should give relevant information correctly and in good faith. Implied consent should not be taken for granted in all cases, even where the customer and the inquirer happen to be very closely related. For example, banker should not disclose the state of a lady's account to her husband without express consent of the customer, and vice versa. The banker may disclose under legal obligations and he will be legally protected to recover the dues in case it is asked for. So, duty to the public. Banker may justifiably disclose any information related to his customer account when it is duty to the public to disclose such information. Recommended a statutory provision. When a government official concerning the commission of a crime, prejudicial interests of the country, customer is contravening the provisions of any law, sizable funds are received from foreign countries. When these things are there in state, banker has the right to disclose. Risks of unwarranted disclosure continue even after the account is closed. It's not necessary the account has to be alive. Even if it is closed, the banker has to maintain the secrecy. The customer may sue the banker for the damages suffered by him as a result of such disclosure in case the account is still closed and then disclosed. Liability to third parties. Banker is responsible to third parties also to whom such information is given. If banker furnishes information with the knowledge that it is false and such party relies on the information and suffers losses. So, general conclusion of the court. Banker answering a reference from another banker on behalf of the latter's constituent owes a duty of honesty to the said constituent. So, another banker when asked for some information, you have as a banker right to disclose. If a banker gives a reference in the form of brief expression of opinion in regard to creditworthiness, he does not accept there is not expected of him any higher duty than giving the honest answer. So, if opinion of a customer is given, mere opinion doesn't risk any banker for on behalf of the customer. If the banker stipulates in his reply that it is without responsibility, he cannot be held liable for negligence in respect of the reference. So, that is the reason every letter given by a bank to another bank is given. This letter is issued on the specific request of a customer without having any liability or responsibility on the bank or the concerned officer signed on behalf of the bank. So, this disclosure will be there. And in that case, the banker, the person who has given or the bank which has given will not be held responsible. I hope the obligations are very clear. Slightly detailed. Please go through for more clarity. And in case you have any question, please put it in the description. I will definitely answer your questions. Thank you very much for patiently watching. Bye bye.